Hello, and welcome to On Air with Akin Gump. I'm your host, Jose Garriga. Hashtag culture has become second nature to many, even outside the confines of social media. This is perhaps nowhere more apparent than with hashtag MeToo. Originally coined in 2006, this shorthand message of solidarity and shared suffering became a mainstay of Twitter and other such platforms, even achieving recognition among many who never use social media. The experience of harassment MeToo represents, as well as the higher visibility claimed by harassment's victims, are now a consideration and a cause of concern in boardrooms around the country. This is the second in a mini-series of podcasts that delve into the topics covered in the 2019 edition of Akin Gump's annual Top 10 Topics for Directors report. And we have with us today Akin Gump labor and employment partner Lauren Leyden. Lauren's practice focuses on leading the labor and employment components of transactional and restructuring engagements, as well as advising clients on the acquisition and structuring of labor. We'll be discussing MeToo and its significance in the corporate world, how boards can protect their company and employees, and how this concept is changing the workplace. Welcome to the podcast. Lauren, thank you for appearing on the show today.
Thanks for having me.
This topic has been a mainstay of headlines and editorial pieces for almost 2 years. So let's start with a little background information to set the stage for listeners. Could you sketch out the rise of the MeToo movement in the United States?
Sure. I think you touched on it a little bit in your introduction. There have been folks using this hashtag and supporting this movement, like founder Tarana Burke, for over 10 years. But it really gained, I would say, national and international attention in every both boardroom and kitchen home across the country during the news and the publicity surrounding the fallout from the Harvey Weinstein allegations. And I think that really made the hashtag MeToo movement relatable to every person. They understood what people were talking about because it was something that played out in newspapers, on TV, and online for everyone to see.
Well, you mentioned Harvey Weinstein, and it seems that, at least initially, most of the news stories covering MeToo focused on the entertainment industry. A lot of big names, a lot of allegations concerning well-known people in front of and behind the camera. So how then is it playing out in the corporate world?
I think it gets maybe less publicity or widespread publicity. Folks that I think sit in my shoes spend a lot of time reading about how it is playing out in the corporate world. And you see some of it in varying, degrees. I think some of it has hit the newsstands, whether it's what the board has been dealing with at Uber, or when the Intel CEO had to, decided to step down for a violation of their internal policies, but still on this subject matter. And we're seeing more and more in the news about how it's affecting our government and how, folks at Capitol Hill are sitting down. Saw this yesterday with Bernie Sanders to discuss some of the harassment allegations in our government. And we're seeing a similar thing play out in the corporate world, where we are seeing more folks not just have these allegations come up, but even in places where there isn't a live claim or a live allegation, you have, whether it be, your C-suite or your board, coming to us and asking us these questions about, well, what if this does happen? Or getting calls from board members that they think something like this is happening, and what do they do about it? Because I think as, corporate boards are more attuned to this being the type of issue that is not something that they, maybe advise and look over, but they don't get actively involved in. I think that there is a recognition that when this involves, especially the C-suite, or depending on the nature of the allegations, even below that, this is part of their responsibility at the board level.
That's a good point. I'll remind our listeners that we're here today with Akin Gump partner Lauren Leyden in the second of our Top 10 Topics for Directors podcasts, and we're discussing the MeToo movement and the impact it is having in boardrooms nationwide. So let's zero in a bit on that. You talked about boards being particularly cognizant of some of these issues. What are some of the steps that boards can take then to protect the company and its employees?
I think they fall into two general buckets. One is about setting a tone of the top and the culture, and the other is about being prepared. I think their boards in general, they do have a culture of their own, sometimes separate from a company, but they really help direct what the C-suite is going to reflect. And I think that in the past, some boards maybe haven't taken the opportunity to make sure that their C-suite understands what they think of is necessary as the company culture, thinking that that is the role of the C-suite rather than maybe a joint role between the board and the C-suite in developing. And then I think it's about being prepared. Boards are better able to handle this if they have set up procedures, policies, thought about this. And I know it's a topic that nobody wants to think about. You're sort of hoping you don't get struck by lightning. But if you prepare for the lightning strike, you are better able to handle it if, God forbid, it happens. And I think that's important rather than shying away from it. I think you want to prepare for it like you would any other type of top-level issue. You have plenty of board procedures and committees set up if there is a problem with the financial reporting. I would treat this exactly the same way, and every board's a little bit different in terms of whether this would be more appropriately handled by the whole board or a committee. I think the first step is to take a look at your governing documents and decide sort of where this would fall. And if it's not already set forth, kind of make a game plan. This is what would happen. If we get this call, this is what happens. Okay, what do our policies and procedures look like in the event of this situation, both for what the board is supposed to do? Do I notify the whole board right away? Do I engage in some fact-finding as part of a committee first? Who's on that committee? And also looking at and getting a report from most likely the general counsel. What are the procedures at the company level when there is this type of allegation, and making sure that it's not a procedure that isn't readily applicable to your C-suite, right? If the allegation is against, God forbid, the CEO, who do you go complain to? Is it realistic to expect someone to go complain to HR in that situation? HR plays a different role in every company, and you've got to think about that. And how much easier to think about that when you're not in the midst of, oh my God, I got this horrible allegation, this call. I've known this person for 20 years. I have all these emotions about it. What do I do? And I have to respond quickly. You will make better choices thinking about this ahead of time, even though it is unpleasant. I would go as far, too, as develop a short list of outside counsel with this type of expertise. Boards do that all the time, like I said, with, if there's certain other types of crises that hit, but you don't do it in this situation. And I would recommend doing it. That way you know who to call. You're not sort of sending out feelers and trying to figure out what attorney you call, who has the right expertise, who is the right fit when you are on the clock and facing things that are, emotional. I think you also want to look at how you as a board would get involved. Would the board want to designate someone in the C-suite or in HR to do the investigation, maybe with the help of counsel? Does the board want to do their own investigation and potentially get involved in speaking to the folks making the allegations or the folks, in the C-suite that the allegations might be against? Now, I'm not suggesting in any way that the board would get involved if this was not at a level of C-suite or something similar, but the board wants to make sure that anyone that they might not be directly involved with in terms of the investigation and the decision, because it just doesn't rise to a board level, there's still the right procedures in place. Maybe it's a 24-hour hotline, making sure that HR is filling the right role so that the things that should be handled at the company level are being handled properly from afar. And then I think you make a separate decision about what the board's role will be and how they will fulfill that role if it rises to the level of allegations against someone in the C-suite.
That's a great point, preparedness, and it's something that I know we've run across, and I know it's discussed in terms of other crisis management scenarios, including things like data breaches. Stepping back a bit, you talked a bit about attention on Capitol Hill and within the government on this. So can we talk a bit about the law itself? To what extent can we say anything about the changes in the law regarding sexual harassment compared to actual changes in the workplace and in litigation environments?
There are, and this is something I hear a lot, right? The law hasn't changed in the sense that the conduct that we're hearing about was not okay 5 years ago. It's still not okay, right? We haven't, sort of broadened the definition of what is misconduct. There have been some changes to the law. For example, I'm sitting here in New York, so I'm thinking of New York. But in terms of, confidentiality restrictions or the ability to require arbitration of certain claims of this nature. So there have been some legal changes that impact this area. But I think the biggest change is how these allegations are viewed both internally and externally, right? It used to be that, these allegations, like I said, they were always horrible. It was always misconduct. No one, that hasn't changed. But there used to be, in my experience, a longer time where people, you went through the court case, right? Or you went to the arbitration and there was a determination of facts and credibility. And there was a longer window where people might have, lived under a shadow of, is this true? Is this not true? What really happened here? But there was a longer process before that direct impact was felt, whether because of a price or customer support or internal, employee outrage and morale issues. I think that time frame and that ability to really get closer to the truth of what happens, I don't think we ever really know, has really collapsed on itself. And sometimes the allegation being out there in and of itself is damaging, and partially because it can suggest that there are controls in place that are not being used properly, right? That HR wasn't open or the general counsel's office wasn't equipped to deal with these complaints, didn't recognize them for what they were. And, the world has decided that means there's a bigger problem there. And I agree, that is a bigger problem, but that used to not be the focus. The focus used to be, did this happen? Did this not? Did it not? And we're going to see it play out in whether it's a settlement or a court case or an arbitration or something like that. And I think because of that, it's another reason why boards really need to be prepared about how confidentiality plays, right? And being very cognizant in this situation of, how you do an investigation, because you should always do an investigation, but you do it in a way that doesn't make yourself unnecessarily and in a way that's not protective of the, of not just the company, but the people involved, open to folks knowing about things well before you've had a chance to even find out what's gone on. And is this a rumor? Is this a complaint? Sometimes it's not sure. And there are steps you can take. And I think there's also an importance of understanding the attorney-client privilege that happens between outside counsel and the board, and understanding how to protect that, because these things do, right? Even though we're dealing with them in a much quicker time frame these days, they ultimately still do end up in that court case or that arbitration. So you always have to think about all of it. I think also, one thing that's hard and that can be helpful by, being prepared and taking some of the steps we discussed earlier about kind of running these scenarios and maybe deciding what works and what doesn't before an actual allegation happens, is being flexible in terms of the remedial steps. A lot of board members that I speak to have, a gut reaction of, I got a call, general counsel said that someone came in and complained about this against the CEO. I want the CEO fired, right? It's this gut reaction of, we're taking an absolutely no tolerance. And I think no tolerance is the right call for misconduct. Do you actually know if misconduct has happened, or do you have any indication that it has? I think to avoid being stuck that there is just, well, you fire the person or you don't fire the person, there's a lot of steps in between that can be taken. And a lot of it depends on the fact finding and an investigation. So knowing and having the comfort of, you don't have to make that call immediately, but you do need to take immediate steps to get yourself into a position where you will make a decision, can really help given this collapsed time frame, which I think has been, and the outside attention has been the biggest change, more so even than the law. I think that's one way that being prepared as a board can really help you deal with the changes that we've seen in our culture.
So just to close, you've laid out a lot of really great information. What were the key takeaways, would you say, for corporate America regarding MeToo?
Be prepared. That, I think that if you hear one thing on the podcast, and I hope they listen to all of it, it's that this is an opportunity to get ahead of things. And just because you discuss it as a board and just because you get prepared, that is, I think, the most important step you can take. You are not opening the door for these allegations because you get prepared. Asking these questions doesn't suggest that you think that there is an issue. It suggests that you want to make sure that there is not an issue, there won't be an issue, and that, God forbid, if there is an issue, you can deal with it in the best way that you're supposed to. So I really think that, engaging someone to guide a board through how this works and what they should do, or looking to their own members who might have, expertise in this area, is a really important thing that all boards should be looking at doing if they haven't done it already.
Thank you. Listeners, you've been listening to Akin Gump partner Lauren Leyden. Thank you, Lauren. That was a terrific exposition and discussion of this critical topic, one that I know will continue to be on employers' and employees' minds for some time to come. And thank you, listeners, for your time and attention. Please make sure to subscribe to On Air with Akin Gump at your favorite podcast provider to ensure you do not miss an episode. We're on, among others, iTunes, YouTube, and Spotify. To read the top 10 topics for Director's Report, please visit akingump.com and search for it by name. And to learn more about Akin Gump and the firm's work in and thinking on labor and employment matters, look for Labor and Employment on the Experience or Insights and News sections on akingump.com. Until next time. On Air with Akin Gump is presented by Akin Gump and cannot be copied or rebroadcast without consent. The information provided is intended for a general audience and is not legal advice or a substitute for the advice of competent counsel. Prior results do not guarantee a similar outcome. The content reflects the personal views and opinions of the participants. No attorney-client relationship is being created by this podcast, and all rights are reserved.